and Elena and Miles Zaremski Law Medicine Forum. This is the first one of the year, I believe. And we are very grateful to have with us not only three of our illustrious professors, but also Miles Zaremski himself, a graduate of this law school, an illustrious practitioner of health law, a recognized expert in medical malpractice law and policy, and also an expert on the Affordable Care Act. So I just want to thank him and his wife for making these meetings, these lectures possible. They will recur through the year, and you're all welcome to attend, so please come back. And now I will turn the program over to my colleague, Jessica Berg, who will introduce the speakers, and let us begin.
Great, thank you. Our format for today is, well, we have a panel of 4 speakers, 3 of our professors, and Mr. Miles Zaremski will join us for the discussion here. Professor Jonathan Adler, Professor of Constitutional Law here, Professor Jessie Hill, also Constitutional Law, and Professor Erik Jensen, a Professor of Tax Law, all of whom will talk to us a little bit about the background of the decision itself. Mr. Zaremski will then follow them with some discussion about the actual impact of the law on practitioners, and we will open for questions. The design of the panel is to allow you to ask questions and have the panel respond, so the bulk of our time will be spent with that. Because we are webcasting, we need to ask that you do come up to the microphones to ask your questions, please. We don't have a mechanism to follow through with our webcast unless you're at the microphones. We can't hear you. So we'll start with a basic background of the decision. We'll basically go down our panel and allow them to make some initial remarks. So Professor Adler, you may begin.
Okay. Well, thanks. So briefly, I'll just start by summarizing what the court did in NFIB versus Sebelius, and then a few very brief thoughts on what significance of the case is. In terms of the court's holding, the court had to decide multiple issues. In this case, the first issue, which Professor Jensen may get into more detail about, was merely whether or not this case could proceed at all under something called the Tax Injunction Act.
No, he won't.
You don't really care much about the Tax Injunction Act anyway. But basically, it's a statute that prevents individuals from challenging the legality of a tax before the tax has been assessed. Basically, you're supposed to pay the tax and then challenge it rather than do it anticipatorily. The court unanimously held that for purposes of the Tax Injunction Act, the penalty for failing to obtain health insurance is not a tax. The court then considered the constitutionality of what we refer to as the individual mandate or the personal responsibility requirement or what have you, the requirement that individuals obtain health insurance, that all individuals in the United States obtain health insurance. The court, 5 of the justices concluded that the individual mandate could not be justified as an exercise of Congress's regulatory power under the Commerce Clause or the Necessary and Proper Clause. It held that the mere presence in the United States without health insurance is not an economic activity subject to regulation as commerce, and that a mandate that all individuals obtain health insurance as a condition on being of existing in the United States was not proper under the Necessary and Proper Clause. Then a different group of 5 justices, the Chief Justice who held made both of those holdings, agreed that nonetheless the penalty for failing to obtain health insurance could be upheld as an exercise of Congress's taxing power, because although it wasn't written as a tax, it functioned as a tax. That is to say that when we, it walks like a tax, it quacks like a tax, so it's a tax, even if that's not the way that it was styled in the legislation. And the Chief Justice argued, at least for himself, that because the statute wasn't written that way, this was enabled by what is called a saving construction. That is to say that if given the choice between striking down a statute of Congress or stretching or massaging the language of the statute to find a way to preserve its constitutionality, the Chief Justice felt it was necessary to do the latter. 4 of the justices felt that such massaging wasn't necessary because the statute could have been upheld either as a tax or as an exercise of the Commerce and Necessary and Proper Clauses. 4 of the justices felt that none of these justifications would work. The court then also held 7-2 that the Medicaid expansion was unconstitutional as an exercise of the spending power. That is specifically the conditioning of pre-existing Medicaid funds, so the Medicaid funds that states have been getting for years, the conditioning continued receipt of that money on a state willingness to accept a dramatic expansion of the Medicaid program was unconstitutionally coercive and therefore not a permissible use of the federal government's spending power. Four of the justices, the four conservative justices, adopted one rationale for why that was very much a function of the size of the money at issue. Chief Justice Roberts, joined by Justices Kagan and Breyer, adopted a slightly more nuanced test that relied upon not just the magnitude of the money at stake, but also the nature of the programs, the fact that Congress was leveraging participation in one program to induce participation in a second program. And that was 7-2. And then the court also held that this constitutional infirmity was severable from the rest of the act, and that the only thing in the act that actually needed to be invalidated was the tying of the receipt of the new Medicaid money to participation, or receipt of old Medicaid money in participation in the new Medicaid expansion, and that everything else in the statute would exist. So the Medicaid expansion becomes voluntary as opposed to something that a state must do to continue to participate in Medicaid funds. In terms of the significance, and I'm overly generalizing, I think there's some beyond the fact that the health care law remains in place. The constitutional significance of this case is that it reaffirms that a majority of this court believes that the federalism jurisprudence of the Rehnquist court was not a blip, was not a footnote, but was in fact a substantive and meaningful limitation on federal power. That federal power is limited and enumerated, and that those limits are meaningful, and that the way to understand the New Deal jurisprudence is that it probably represents the outermost scope of federal power, and that federal power that seeks to go beyond that scope must have some exceedingly persuasive justification for why it is constitutional if it is unprecedented. And as I suggested at the prior forum that we did on this question was really the underlying constitutional question or paradigm question at issue in this case, whether or not Congress generally had what was close to a plenary power in economic matters with a few footnotes for a handful of Rehnquist court opinions, or whether or not these limits were meaningful. And at least for the time being, this decision represents that a majority of the court believes that these limits are meaningful. The last thing that I think is significant about this case, in just thinking about this court, is it reaffirms that among the conservative justices on the court, there remains a very powerful minimalist streak, and this is seen most vividly in the jurisprudence of the Chief Justice, who in this case, as he has in many cases, has felt the need to do things as narrowly as possible. So his decision to say that let's stretch this language to see if we can uphold it as a tax, even though that's not what we think the language on its face means. Let's excise as little of the statute as possible when we find something unconstitutional and leave the rest standing. These are things we've seen the Chief Justice do before. It's something that we've seen generally as a pattern, not an unbending rule, but a general pattern in the court's jurisprudence. And it's significant. So while the court is reaffirming a generally conservative approach to these sorts of questions, it is also a court that is acting in a very minimalist way as it moves in that direction. And with that, I will turn it over to Professor Hill.
Thank you. So as many of you know, Professor Adler and I did not agree on very much about the case before it came down. I think afterwards, there's actually not much, for example, in what he's just said that I could disagree with. I might disagree with the characterization of it as a reaffirmation of some aspect of the Rehnquist Court's federalism jurisprudence, because I don't think it was reaffirming anything. I think it was going beyond that and finding something in it that was not there. Even in that line of cases, but beyond that, I think it's a very fair summary. I think I agree with a lot of what he sees in the opinion. And, I think it's interesting that considering how closely watched this case was from a constitutional perspective, I would say, again, narrowly, not in health policy terms, but in constitutional terms, if you ask me what the impact of the case is likely to be, it would be a pretty definitive meh. Right? Not really. I'm not quite sure. And I don't see big tectonic shifts here for a couple of reasons. I mean, I think first, the Commerce Clause holding, it's unclear whether it's going to have any impact in the future. What other attempts is Congress going to make to regulate quote unquote inactivity? Sure, you could try to characterize a lot of things as inactivity, and there are some questions that could arise, but folks have been racking their brains to come up with examples, and there just aren't a lot of them out there, at least on the current model we have of federal legislation out there, current kinds. It's hard to see anything that's currently out there that's vulnerable to attack, in other words. In terms of the taxing power holding, I suspect Professor Jensen has a different view, or I know he has a different view, but I personally don't think that was a big departure either. The taxing power, in my view, has always been extremely expansive. I think characterizing it as a tax is a really fair characterization, a totally reasonable one. I think, there was some question, and I am a little surprised that the court had the chutzpah to call it a tax for taxing power purposes, but not for Tax Injunction Act purposes. I think a lot of people didn't think they'd go there. But other than that, again, I don't personally foresee huge changes on the constitutional taxing power front. Finally, I think the biggest change to the doctrine is probably to the Medicaid, in the Medicaid portion, to the 10th Amendment, because there's a real limit. The court has finally struck something down it hasn't done so in many decades, as exceeding the spending power. So we now know, we don't have to speculate what might not qualify as a legitimate exercise of spending power. We finally have an example. We still have a huge gray area where people are going to be asking, what about this, what about that? There will probably be litigation in the future. This is an area where I personally suspect in practical terms the Medicaid holding is not in the end going to make a big difference, because I suspect that every state is ultimately going to take that money. They're going to posture about it for a while and pretend like they don't need the money. They're not going to take the federal government's handouts. And in the end, just like they did with the original Medicaid program, every one of the 50 states is going to decide it cannot leave that money on the table. But again, I could be wrong. I've been wrong before. And then finally, I think that the only other point I want to make is that certainly there may be questions left unanswered. There may be litigation in the future. Of course, there is ongoing litigation currently over the contraceptive mandate, which is under the aegis of the Affordable Care Act, but not, wasn't involved in the Sebelius decision. I also think that there are interesting issues, and potentially, although it's a little bit more of a stretch, some constitutional issues around how states are ultimately going to define terms like medical necessity and essential health benefits, where there's a lot of leeway currently in the statute and a lot of political wrangling and compromise over that. But I will leave the rest to the experts.
I am a bit of an outlier here, because even though I'm fairly healthy, I don't know very much about health law. So I'm just really going to talk about what the case said, I think, about the taxing power. And I think I agree with Professor Hill that the ultimate effect is not likely to be very, very significant. Well, the narrow holding of the case on at least the part of the case that I'm concerned with, is that the individual mandate penalty, the penalty if you do not acquire suitable health insurance beginning in 2014, will be a tax, even though Congress didn't call it that, even though it made no findings based on the taxing clause. All of the findings were associated with the Commerce Clause. It will be a tax, and will not be a direct tax that, nobody knows about direct taxes. Direct taxes have to be apportioned among the states on the basis of population. That simply wouldn't work here anyway. This is, although a tax, not a direct tax. And this holding is the effect of the Roberts opinion, joined, I think, very reluctantly on this point by Justices Ginsburg, Breyer, Sotomayor, and Kagan. So to begin with, this is a fairly weak group of people, agreeing only at the margins. And I'd like to emphasize what the case did not hold under the taxing clause. The case does not say that the mandate itself was an exercise of the taxing power. I hear all sorts of people talk about the court said it was constitutional under the taxing power, and it's very important to figure out what the it is, what the antecedent of the it is. And Chief Justice Roberts specifically did not say that the mandate itself was an exercise of the taxing power. In fact, in discussing the taxing power, he basically characterized the mandate as not a mandate. It's not that you're really required to go out and get insurance. You have a choice. Either you can acquire suitable insurance, or in the alternative, you can pay this penalty/tax. And as far as Congress was concerned, Congress was indifferent about your choice. You could do your own little cost-benefit analysis, and if you decided paying the penalty made more sense, that was fine. So the mandate really isn't a mandate for purposes of the taxing clause analysis. And just one interesting thing to me about the Roberts' opinion is how differently he characterized the mandate when he was analyzing the arrangement under the Commerce Clause, where he was using words like force, compel, require. But for taxing clause analysis, that simply isn't the way he viewed the mandate. Another thing that the court did not hold, did not conclude that the mandate together with the penalty/tax was a valid exercise of the taxing power. I mean, that was an argument that had been raised in lower courts by the Obama administration. Basically, the argument was this was fundamentally a revenue provision, revenue statute with associated regulatory provisions, which always struck me as getting the whole thing backwards. Anyway, that argument basically dropped out at the Supreme Court level, and that's not a holding of the case. The court also did not hold that arrangements that might be recharacterized as taxes conceptually, or that might be viewed as in substance the equivalent of a tax, were valid exercises of the taxing power. The Chief Justice said something to the effect that a tax involves a payment of cash to the government. So form matters here. If you don't have something like that, it is not a tax. And finally, the court did not hold, as some commentators had suggested that it should, that any government enactment that is funded by taxation is in effect an exercise of the taxing clause, and therefore valid under that clause. Since almost everything the government does is funded by taxation, that would have been an incredibly broad holding, but that's not what the court said. So again, the holding is incredibly narrow. It is that this penalty is in effect a tax, and therefore valid under the taxing power. So given the narrow nature of the holding, I mean, that's actually one of many reasons why I think that this case is not going to lead to any significant expansion in the use of the taxing power. And our critics on the right have expressed concern that the reliance on the taxing clause in this case could lead to a dramatic expansion of congressional power under the authority of the taxing clause rather than the Commerce Clause. It seems to me that's not going to happen, and those on the left who hope that something like that will be disappointed. And I could provide some other legal reasons why I think this is not going to lead to any significant expansion, but there's also a political consideration here, and I'm not sure it's really a good thing for future political discourse that any time there is consideration of a potential regulatory penalty, that folks who are opposed to that are going to be able to say, well, that might be a tax, not for constitutional law purposes necessarily, but just for purposes of political discourse. And you are suggesting that we have an increase in taxes, and I'm going to resist that provision for that reason alone. It seems to me that viewing almost any penalty as potentially a tax for purposes of political discourse may well lead not to an expansion of actual congressional power, but actually further congressional gridlock, if such a thing is even possible.
Well, first of all, thank you for inviting me to participate, and I thank Professor Mellman and all the faculty, some of which I know well. And I couldn't be more delighted to be here. And as I was waiting my turn, I was thinking the last time I was here was probably in this chair taking my final examination nearly 40 years ago. The point I want to make is that I've been in healthcare law. In fact, I came to the law school because of the Law Medicine Center, because of my interest in law, medicine, and healthcare way back when. And of course, it was in its infancy, and now the whole field has developed so much. And those of you here today who have an interest to pursue health law in whatever aspect, whether it's on the bench or in academia or in practice or in government service, you couldn't be at the right time, more at the right time than you are now. After listening to three distinguished faculty members, my first words as a part of an introduction would be, now what? And what I mean by that is that we have a federal law that's in place, that's 2,000 pages or so. My presumption is that it will remain the law after November 6th. This is not a political discussion, certainly this afternoon, but I think whoever rises up to become our next president, I think the law is going to remain. That having been said, I would then categorize the Affordable Care Act as a metastatic law, in the sense that it provides you all that are entering the field or maybe you're in the field already as a full employment act for the next many, many, many years. Not only, we can look at the 1965 Medicare law that came into being then and seeing how it's developed and the work that it provides lawyers as well, but the Affordable Care Act kind of has its tentacles in many, many areas from a pragmatic point of view, from a practice point of view. And let me just, as part of my introduction, I'll tell you what I mean by that. And I'll quote from another article that's captioned Tennis Tournament and Fall Social, but it was for Mississippi lawyers. But it has a part that I'd like for you to mention. As an example, what should a domestic relations lawyer do to require, to the extent possible, a client's former spouse to obtain federally subsidized family coverage through a state-run insurance exchange? As we know, part of ACA is to create state insurance exchanges that have to be up and running in 2014. How will the Affordable Care Act affect personal injury settlements and the taxation of settlement payments? I'll look to my distinguished colleague to the right for an answer to that. Will the role of the Affordable Care Act's Elder Justice Act play in tort suits brought against nursing homes? How will that be implemented? Is the Affordable Care Act increased child adoption tax credit material incentive for a client who's involved in the domestic relation issues? How will the Affordable Care Act affect wealth management, estate plans, and estate planning, business sales, corporate mergers and acquisitions, new financial burdens imposed on borrowers, coupled with the bankruptcy priority of those debts that affect lending decisions? How will ACA impact that area? So when I say that it's a metastatic law, I'm not saying it in any illness-related vein, but to tell all of you out there that this act will create much work, and I haven't even mentioned the litigation. I'll mention that as we go forward today. In terms of the various portions of the act that are being challenged, have been dismissed, have been appealed, etc. So I think it, for someone having been in the field all these years without the Affordable Care Act, but now we have the first major health care law short of Medicare in 1965, I think for all of you, I think the sky's the limit in terms of what you want to pursue.
Thank you very much. Okay, we can take questions, comments, but again, I'd like to remind you to please move to the microphones in order to facilitate our webcast.
It's a new student.
I have a question, and that is one that's often been asked in the wake of this decision. As my friends, I have a question, which has often been asked in the wake of this decision. As my friends in California might put it, what was Robert smoking? In other words, how do we explain what I thought was a rather extraordinary decision on his part?
Which part? I think the way to understand it is twofold. One, Roberts believes that the federalism jurisprudence of his former boss, Chief Justice Rehnquist, for whom he clerked, was not carving out a tiny exception to what is a very expansive commerce power, but was, as Chief Justice Rehnquist wrote in the Lopez opinion, an assertion of first principles. And that and we'd seen inklings of this in Roberts' prior writing. His very first opinion as a federal judge was a dissent from denial of en banc in a case called Rancho Viejo, where he adopted a very formalistic approach to understanding the commerce power, which you can also see in his opinion. So it's not that what he did on commerce was particularly unprecedented. I think doctrinally it's very similar to what the court did in Lopez. What was surprising is that most academics didn't think that that was the law, but most academics didn't predict Lopez, didn't predict Prince, didn't predict New York, didn't predict Morrison, didn't predict Alden versus Maine, and so on. I mean, there is the paradigm that most legal academics have operated on in these areas is different from the paradigm that about half of our judiciary operates on. The second part is, in terms of his opinion, I think is explainable by this minimalist streak. That is to say, Chief Justice Roberts, who also clerked for Judge Friendly on the Second Circuit, who was very much a minimalist judge, believes in his core that, as he put it in his confirmation hearing, you don't go to the game to watch the umpire. And what I think we're learning he means by that is judges should do as little as possible. And that means if you can avoid striking down a statute, you avoid it. This is what he did in his Voting Rights Act decision. But no, he adopted what was an even more implausible reading of a statute to save its constitutionality. According to Jeff Toobin's reporting, he tried to do that in Citizens United, adopt an implausible reading of BICRA to save it, but he was the only justice on either side willing to do that. As we saw in Free Enterprise Fund, another decision of his, if there's something wrong with the statute, you use the finest scalpel you can find, and you carve out just that little bit, and you leave as much standing as possible. And then beyond that, this is also a piece of his general approach of preferring as-applied challenges to facial challenges, taking a very narrow view of things like standing, which is a way of divesting the courts of authority to answer things. So we can agree or disagree whether or not this is what judges should do. But I think, as the dust settles in terms of people's personal views about the rightness and wrongness of the decision, if we just want to explain what he did, we can see these two aspects of the opinion are very consistent with his general approach as a judge. He's a conservative formalist who believes in federalism, but he also likes doing as little as possible.
Go ahead.
Oh, no, go ahead. Go down the line.
Are you sure?
Sure.
Well, okay, so if I could present a slightly contrasting view. I mean, I think the question is not what was he smoking, but what was he drinking, maybe the Tea Party tea or something. I think, personally, I do think that this was a departure. I think that, academics didn't predict Lopez maybe and Alden because they were wrong and the academics were right. I mean, that's another interpretation, right? Because they were unprecedented. They were a new direction to go. And I think that that's what's going on here too, is that the court has taken a new direction. And I think the decision was kind of Marbury versus Madison-like in its political cunning, in the sense that, I don't think this makes a huge change immediately, but it seems that there were seeds planted for the future potentially that could change Commerce Clause jurisprudence. Maybe. I mean, certainly it was throwing a bone toward that constituency, yet while not actually doing making the really big move of declaring the Affordable Care Act unconstitutional, which would have had a lot of political backlash. I mean, I see it as political through and through. And it's true that, the Roberts Court has not had a big appetite, I agree, for overruling big precedents or, making these bold decisions. They've cut back on
on, standing in, or in the Establishment Clause arena without overruling the precedent that they were obviously essentially overruling. They did the same thing in the abortion rights arena. I mean, this has been a pattern, so I agree with that. But I do think, it's, and also a lot of people have speculated the way that the four conservative justices basically wrote the same opinion as Roberts, but didn't join his opinion, kind of indicates that, he made a last minute change of heart, and they were kind of annoyed, and that this was a political decision. So I definitely think that's what's going on.
I'm a kind of a pragmatist as well. But having read the opinion a couple of times, I still can't figure out the meandering river that Roberts took to get to his result. And I'm not speaking from an academic point of view, just a pragmatic point of view. But what I think, and we'll never know, but I think that he saw this court being his court and not the Rehnquist court, who had Bush versus Gore, but he certainly had Citizens United. And I think perhaps at the end, he had a goal in mind, and somehow to keep this law valid, and he went ahead and did it, so that the Roberts Court won't be known as a political court. And of course, we'll never know, obviously, but just in terms of the reading of the decision, it doesn't flow well in any way. But I think his decision balances the court, even though perhaps the decision from a scholarly point of view isn't the best written decision that I've ever read out of the U.S. Supreme Court. So that's, to answer Professor Melman's question, I don't think he was drinking anything or smoking anything. I just think his ego played into it somewhat, perhaps, and it's his court. And if that court were to overrule the signature legislation of the president, the court probably would be looked at no longer as having that impartiality that we all think it should have.
Just two things just to think about that in terms of that interpretation. One is, it'd be an odd move, and I have problems with aspects of the Chief Justice's opinion, but it would be an odd move to save the court politically that, based upon the polling that up in the spring, suggested that a majority of Americans both wanted the mandate struck down and, I think more significantly, expected it to be struck down. So it'd be an odd calculation to make, to say, I'm going to save this court's political reputation by doing something that a majority of Americans both neither want nor expect. That would just be odd. And I think assuming that justices take their oath seriously in trying to explain their opinions on those grounds makes more sense. The other thing, just in terms of striking down a president's signature legislation, we've seen that done by the Roberts Court in a case called Boumediene, where a statute, unlike this one that had strong bipartisan support, that was enacted in part in response to a prior Supreme Court decision, and that was the signature piece of legislation as part of President Bush's war on terror, the court struck it down 5-4, Justice Kennedy and the four liberal justices, in what is, and this is a descriptive statement, not a normative statement, because there's lots to like in this next statement, in what was clearly the single most aggressive exercise of judicial review of a statute adopted for national security purposes in the entire nation's history. Now, there are a lot of reasons why we should think that is a good thing, given the counterexamples in our history. But just in terms of a description of the court's behavior, of it confronting the political branches, of it confronting the centerpiece of a president's agenda, we've seen that in the last 10 years. And the court seems to have survived just fine, having done that. So again, I resist those sorts of interpretations when there are other ways of explaining why the court behaved.
Can I just? I'm a little skeptical that the Tea Party folks think that they were thrown much of a bone in this case. The result is not the result they wanted. Their concern about the purported expansion of the taxing power, I think, is overblown. But they certainly do feel that part of the opinion is dangerous. The striking thing about the case to me is not so much the result, upholding the individual mandate penalty, but the reliance on the taxing clause, because I know of very, very few people in the world across the political spectrum who expected the result in the case to depend on the taxing clause. And there was thought that the taxing clause could have been an alternative justification for the individual mandate penalty, so authorized under the Commerce Clause, but also would have been authorized if necessary under the taxing clause. But that the taxing clause became determinative was really, really striking, and I think almost totally unexpected.
So maybe the real surprise was that it's not only full employment for health lawyers, but for tax lawyers.
For tax lawyers.
No, but tax lawyers don't pay attention to constitutional issues. No.
Yes.
I remember when the law was first passed. There were allegations that this law could perhaps open things up to abuse by the insurance companies, that the insurance companies say, aha, now everybody has to pay insurance. Why not just raise the rates sky high? There was also the claim that this, in fact, did happen when the law got passed, and that the insurance rates would keep going up and up because people have to pay them. Do you think that this claim is true or false? And do you think that we're going to be looking forward to higher and higher insurance rates, perhaps geometric increases in insurance rates in the future?
Let me start off with that. Before the law was passed, insurance premiums were going up. After the law was passed, insurance premiums were going up. Not much positive news there. And the reason, principally, certainly before the law, there was nothing to constrain insurers from increasing premiums unless a particular state had enabled its state insurance commissioner to review rate increase requests, and some states have it, a lot don't. But the Affordable Care Act really primarily addresses accessibility to health care, not affordability. So the area of affordability still needs to be tweaked as we go forward. But one would say, well, geez, every person now has to be insured or face a penalty, a tax. So why should the insurance companies want to raise rates? Well, they're in the business to make money. They're in the business not to pay out. They're in the business to insure healthy people. That's just part of capitalism, an American way of life when it comes to the insurance industry. So while they're going to be getting lots more money, there really isn't an effective mechanism in place or effective competitive mechanism in place until at least 2014, where we have the insurance exchanges up and running, although some states are refusing to do so for a variety of reasons. But with those insurance exchanges, some states just won't go along with it, and the federal government will step in, which effectively will be the public option that was defeated or couldn't get past first base during the negotiations for the Affordable Care Act in 2009, leading up to its passage in March of 2010. So the answer is, absent true competition, either through state exchanges or through the federal government stepping in, like through its co-op program under the Affordable Care Act, don't be surprised to see premiums increase. You need either a state's regulatory scheme to limit requests for increases, or through state insurance commissioners, or you need true competition through these exchanges that will then lower premiums.
Professor
But, I mean, isn't there, and I'm no expert in this particular aspect of it, but isn't there a limitation in the form of certain required medical loss ratios that says that the insurance companies have to spend a certain amount of their income on actual paying out of claims, and they have to refund, right?
That is correct, Professor. There's an 80-20 medical loss ratio. That is, for every dollar, the insurance company has to spend 80 cents on the benefits, or else they have to refund, as they did in August. I think it was by a total of $1.3 billion back to those that bought insurance policies, either the employer or the individual. So in that sense, the insurance companies have to but the medical loss ratio really has to do with benefits versus administrative expenses, not increasing the premiums. They can still increase the premiums, but if they're not spending 80 cents on the dollar, you know, or no more than 80 cents on the dollar, you know, they still have to refund that. So I think there's a little bit of a difference here.
Yeah, I would just say, I mean, the insurance premiums are going up. They will keep going up. There's very little in the law that will put any downward pressure on insurance premiums, and lots of things in the law that put upward pressure on insurance premiums. The mandate was something the insurance companies demanded in return for not fighting so much against guaranteed issue and the requirement to not penalize people for pre-existing conditions. The insurance companies wanted a much higher penalty because the penalty for failing to obtain insurance is substantially less than the cost of insurance for most folks that will be subject to it. And an interesting consequence of the Supreme Court's upholding it on tax grounds is Congress's ability to raise that penalty is now severely limited. Because one reason Roberts said it's a tax is because it leaves people a choice and because it is relatively small compared to the alternative of acquiring insurance. So we don't know quite where the line is, but we know under that reasoning, Congress cannot, for example, make the penalty greater than acquiring insurance. And the CBO's post-decision estimate is that there will be 30 million people that remain uninsured under the law, and that's assuming states accept the Medicaid expansion, and that's assuming states all end up having insurance exchanges, both of which I think are in serious question. And of that 30 million, only 6 million will pay the mandate penalty, although the vast majority of that 6 million are folks that make below $200,000 a year. So that's a significant number of people that are paying increased taxes. So we will see rates continue to go up, and we saw the same thing, or seeing the same thing in Massachusetts, right? That the Massachusetts law that parts of this legislation were based on did quite a bit to expand access, but did absolutely nothing to control costs.
But again, I mean, the increase would be largely because of the increasing cost of healthcare and not because of massive profit taking by insurance companies, because that's what the medical loss ratio is intended to prevent, right? I mean,
but guaranteed issue puts significant upward pressure
that's
on
why the mandate
and minimum essential benefits puts upward pressure on healthcare on health insurance costs, because it prevents insurance companies from offering the sorts of plans that, say, for example, people in their 20s who are relatively healthy might prefer, that have relatively minimal benefits, but insure against catastrophic harm. Those sorts of plans are insurance companies are going to be less able to offer those sorts of low-cost plans for many consumers, although it depends on your age, and there are all sorts of regs about what you can offer in exchanges.
There's one other footnote to all this, and in that, I guess, could be something in the political vein, and that even though, you know, you hear the politicians running for office currently will, particularly those who oppose Obamacare, say that, oh, look, it costs more to get insurance, and we have this grand new law that, you know, should be done away with. That is really kind of a ruse, in the sense that the law was never, you know, despite all the efforts, and the law has tremendous benefits, which, you know, I've hit, you know, there are multiple benefits in the law. But the law does not, as Professor Adler and Professor Hill has said, doesn't put a clamp on the ability of insurers to raise premiums. And only through true competition, either through these state exchanges, or if the federal government gets involved because states won't create these exchanges, will there be pressure on insurers to limit their increases in premiums or keep them flat.
Great, thank you.
It strikes me that this is just the first round of legislation in this area. And what constitutional challenges do you foresee going down the road in order to, if you will, enact and fine-tune the core policy values that you're seeing in this act?
I mean, I can respond to that a little bit, and I think it's in my mind it's speculative right now in terms of future constitutional challenges, other than the sort of constitutional and statutory contraceptive mandate challenges. I think to take a step back, I mean, I think that, healthcare in the U.S. has always been highly decentralized, right, and privatized to a large extent. And I think that with the Affordable Care Act, one of the big implications is a greater centralization and a greater role for government, certainly, in the provision of healthcare. And I think that, we're starting to see how that's affecting the national conversation over what healthcare is and what constitutes healthcare and what does healthcare mean, and is reproductive healthcare part of healthcare? Are other things part of healthcare or not part of healthcare? And again, the contraceptive mandate fight is part of that. What are essential health benefits is another piece of that. I've suggested, and again, I think it's very speculative. This is very sort of law review-y, but I think it could come down to some challenges around if the government defines those benefits or in certain ways that would that are too narrow, that might impact individuals' ability to access certain health services, that there could be substantive due process type claims arising out of that, or equal protection type claims. And if you think of, this is sort of very hypothetical because it's not really a foreseeable thing. But, if a state were to define essential health benefits to exclude, race-specific conditions or associated predominantly with certain racial groups like Tay-Sachs or sickle cell anemia or something, you could certainly see where there would be constitutional challenges around that. And, the question becomes, to what extent, now that the state is playing a bigger role, can it really define certain things out of healthcare or not? In my view, that might, but that's down the road. I think if things develop in a certain way, that could happen.
Most of the challenges that we're going to foresee into the Act and its implementation are going to be statutory-based challenges. The contraception mandate, of which there are now, I think, about 30 contraception mandate cases around the country pending in federal court. There's a strong claim there, but it's a Religious Freedom Restoration Act claim, not a First Amendment claim. And it's narrow in the sense that the strongest claimants are religious institutions that self-insure, many of which self-insure. That is, they are both the employer and the insurer themselves. Many of them self-insure as a way of getting around state contraception coverage mandates, because a lot of states have such mandates, but self-insuring entities can generally get around that. Most of the other challenges that we're going to see are statutory challenges. There's one that I have an article coming out in Health Matrix that discusses relating to tax credits for exchanges. There are a lot of constitutional challenges that are being filed. Substantive due process challenges, origination clause challenges, equal protection challenges about treatment of physician-owned hospitals as opposed to other hospitals. Most of those are Hail Marys. We may see some constitutional litigation trying to clean up the edges of the Medicaid holding. So, for example, there are provisions in the law that purport to prevent states that voluntarily provide broader Medicaid coverage than the federal government requires. There are provisions that are supposed to prevent them from reducing back to the federal minimum. And there's a question about what the federal government can threaten states in that regard, arising from the Medicaid holding. Maine tried to raise this in a case just recently, but it really wasn't ripe yet. So we might see something like that. But again, short of the contraception mandate, the only other area where we'll see, we I think will at some point see constitutional litigation, but it's unclear what direction it'll come from, is relating to something called the Independent Payment Advisory Board. This is the 15-person panel of folks that will make decisions about Medicaid reimbursement, and some people hope will provide a basis for deciding generally in the healthcare system what sorts of treatments can be paid for and at what cost. And as an administrative law matter, there are lots of constitutional problems with it. Among other things, the fact that it's not subject to judicial review, that Congress can only eliminate the IPAB if it introduces a joint resolution in a narrow window in 2017 and follows a special procedure in repealing it. It means it's these bizarre restrictions on Congress. So you could see challenges to that structure. You also, as Professor Hill noted, if IPAB ends up saying the federal government will not reimburse under Medicare, for example, certain sorts of procedures beyond a certain amount, and that amount is too low for anyone to get that procedure covered, there are equal protection and substantive due process claims that we could imagine that that might manifest, and they'd probably cite one of Professor Hill's articles too.
One would hope.
But I mean, you know, until we see what the IPAB does, it's hard to know precisely what that looked like.
Yes, do you want to make
Let me add, in terms of all of you wanting to go into healthcare law or become healthcare practitioners if you aren't already, and that is, you know, besides the transactional matters that are going to arise left and right, I mean, they're going to involve medical device manufacturers, pharmaceutical companies, life science companies, insurance companies if you're representing insurers in coverage decisions, providers, health systems that want to acquire individual or group providers. I mean, the list goes on and on. But add to that list if you want to be a litigator, or if you are a litigator, particularly in this area. As Professor Adler alluded to, there have been a number of challenges to the religious freedom issues and contraceptive issues, but there's been a number of existing lawsuits that are, most of which have either been decided or been dismissed. I know the Liberty University case out of the Fourth Circuit, which really didn't become part of the U.S. Supreme Court's decision, has asked that the Supreme Court reinvigorate the case and send it back down to the Fourth Circuit. The court has asked the Justice Department, I think a week or so ago, to file a brief within 30 days. So perhaps the court is going to look at those issues that weren't decided by its case back in June. But there's going to be a plethora of litigation. So if you're inclined to be a litigator or trial lawyer and a health lawyer, the sky's the limit as well for you.
Professor Hoffman.
Well, first of all, thank you for an excellent panel. I think we all learned a lot. You've mentioned very briefly the contraceptive issue, so I thought maybe for purposes of the audience it would be good to say what that is in case people are not familiar with it. And also, how do you think that litigation will come out? Because I know that there have been now numerous cases filed.
Yeah. Okay. So, so the Obama administration, and the timing, I'm not even going to make an attempt at because I don't recall offhand. But the Obama administration announced initially that all new insurance plans would be required to cover contraception for all FDA forms of contraception, basically, with no copay and no additional, I guess, it could be cost sharing, right? That's the word. And no cost sharing, and there was a very, very narrow exemption for religious employers who were providing insurance for their employees, and it defined the exemption defined religious employers in such a very narrow way that virtually every church or thing that is like a church would be covered, but almost nothing else would be. So, Catholic charities or religious social services organizations would not, hospitals, schools, et cetera, would not get the benefit of this. This is actually a battle that has been going on much longer than this through the state legislatures that had very similar mandates. They were initially upheld. There were a couple of cases in California and New York upholding identical mandates, but it's different when it's on the federal level for a reason I'll talk about, in a minute. But anyway, after issuing this rule, and there was a big uproar and so on, the Obama administration kind of backed off of it and said, well, okay, wait, we'll take a year, we'll give you an extra year to figure this out if you're a religious employer or an employer who objects on religious grounds to providing contraceptive coverage, and we're going to issue a new rule that basically ensures access to women for contraceptives directly through the insurance company, but employers won't have to pay for it. So the insurance company will have to provide it, but the employer won't have to pay for that portion of the coverage. We haven't seen the actual rule yet. It isn't out there. So, because they've got a year now to figure it out and figure out what it's going to say. So, I think in the immediate term, the answer is that most of these cases, so there has been at least one case that's come out saying that rejecting the claim. I think it's difficult now because it's not clear exactly what the requirement is going to look like when it's issued. But
the difference when this mandate is issued on the federal level is that it's not really a free exercise claim under the First Amendment. It's a claim under RFRA, the Religious Freedom Restoration Act, which gives a lot more protection to religious entities than the First Amendment of the Constitution does. But it only applies to when the federal government acts and not when the states act. So although these claims were, dead in the water and both, they got litigated, but they both lost. They were both complete losses in California and New York when California and New York enacted identical mandates. At the federal level, it's different because a different set of rules applies to the federal government's impingements on free exercise. And the real difficulty is, I think it's true, the difficult case is what Professor Adler said when the employer self-insures and is both the employer and the insurer, because we don't know, but presumably the employer is going to have to absorb the cost of insuring.
Just a couple really brief things I'd add to that. One potential difference on the First Amendment claim would be is that under all the state mandates, employers have multiple ways of trying to avoid the mandates. For most states, they can drop prescription coverage as part of their plan, but both self-insurance or essentially, and I'm oversimplifying, subjecting themselves to federal regulation under ERISA essentially gets them out of the state rules. So the First Amendment claim is marginally stronger against the federal government than against the state governments because there is no equivalent opt-out or way of avoiding the burden. The thing that's really interesting is the legal point, and courts have been struggling with this, is that when the day the administration announced that they would create an accommodation, they went ahead and finalized the original rule. So that's the rule that's in the book. So if the administration does nothing, or wherever the next administration does nothing, the regulation is in effect now, and the 1-year grace period of promised non-enforcement will eventually go away. And the big problem is that it's not clear that under the law the administration has the ability to tell insurers you must cover this but can't bill your clients or can't bill the employer. It's not clear there's any authority to do that. And the statement that the vice president made in the vice presidential debate about no religious employer being forced to pay for it cannot be done if this applies to religious employers like universities and social services. There's no way to avoid them making them pay for it because they are both the employer and the insurer. And not only is there no rule to do this, there's not even an outline or even a paragraph suggesting how this circle could be squared under the current law. The administration just said, we promise you we'll do something, and punted. And legally, it's not clear there's anything they can do without backing off the mandate, and that itself could create problems because contraception is considered a form of preventative medicine, and the law does say that preventative medicine is supposed to be made available in these plans without cost sharing. So, the administration is kind of between a rock and a hard place. Any administration trying to implement these commitments would be between a rock and a hard place.
We have like 30 seconds.
Okay. District Court in St. Louis struck a case that was brought, and the district court there, Judge Carol Jackson said, RFRA is a shield, not a sword. It is not a means to force one's religious practices upon others. It does not protect against a slight burden on religious exercise that arises when one's money circuitously flows to support the conduct of other free exercise-wielding individuals. Now, I will question that if it's okay for insurers to pay for these kind of benefits, but not the employer, I would have to question just what kind of premium the employer is paying to the insurance companies for coverage. And no doubt the argument can be made, well, part of that premium goes to pay for services that we find objectionable.
Great. Well, that runs us out of time, but thank you so very much, and join me in thanking our panel.
Thank you.